It is not easy for people to see images of police officers snuffing the life out of people or shooting people to death, snuffing the life out of people, as was the case with Eric Garner in New York, and as was the case of George Floyd in Minneapolis. It is not easy for people to see that, and it is customary for folks to hear and for police agents to say that these are simply examples of, quote, bad apples, bad apples, bad apples. At what point do we begin to ask, how is it that so many bad apples show up in so many police departments on so many occasions without someone beginning to ask, who's picking, who's selecting these apples? Who's recruiting these apples? And these are just the apples that we know about. What about the apples that we do not know about? What about the apples whose conduct has gone unreported, unvideotaped? Because there were no smartphones available, or because in the era of body cam footage, the body cams were not operated. I wrote several years ago that body cams are not a panacea. They're not an answer. Body cams are not a substitute for character. The same person who will do an abusive act to another person will abuse a rule about operating a body camera, or will not turn the body camera on conveniently, or will manage to have the body camera footage conveniently lost, deleted, made unavailable. The problem we're talking about, however, is not new. Justice Leon Higginbotham, Judge A. Leon Higginbotham, in a book titled Shades of Liberation, Racial Politics and Presumptions of the American Legal Process, recounted a, quote, particularly egregious civil rights violation, close quote, in his discussion of a case that went to U.S. Supreme Court in 1936, titled Brown versus Mississippi. Listen to what Judge Higginbotham wrote. Listen very carefully. In 1934, three impoverished and ignorant African Americans in Kempner County, Mississippi, were suspected of murdering a white man. A deputy sheriff and several of his white cronies brutalized the defendants with some of the most extreme torture ever revealed in a reported American case. One defendant, Yank Ellington, so enraged a mob of 20 white men with his professions of innocence that they whipped him and twice hung him from a tree before finally releasing him to return home in agony. 2 days later, the deputy again seized Ellington and took him to jail by a circuitous route that led into the state of Alabama. While in Alabama, the deputy again severely whipped the defendant until he, quote, agreed to confess to such a statement as the deputy would dictate, after which he was delivered to jail, close quote. The same deputy then arrested two other African American men, Ed Brown and Henry Shields. One night, the deputy, the jailer, and several other white men made the defendant strip. The two men were then, quote, laid over on chairs, and their backs were cut to pieces with a leather strap with buckles on it, close quote. They were repeatedly whipped and told that the whipping would continue until they admitted, quote, in every manner of detail, close quote, a confession, quote, in the exact form and contents as desired by the mob, close quote. During a 2-day trial, the rope burns on Ellington's neck were clearly visible, and the deputy sheriff and others freely admitted to beating all 3 defendants. The deputy testified that Ellington's whipping by the mob was, quote, not too much for a Negro, not as much as I would have done if it was left to me, close quote. Despite the clear evidence that the defendant's pretrial statements were coerced, the trial court denied the defendant's motion to suppress the confessions. The 3 men were convicted and sentenced to death. The aggressive young attorney prosecuting the case was, listen now, John Stennis. And he did not deny the severe police brutality. This case was one of the first steps in a political career that would later lead Stennis into becoming an, quote, esteemed, close quote, member of the United States Senate. Now, before you say this was 1936, let me show you how pertinent the Brown against Mississippi case is today. Do a Google search for United States Navy aircraft carriers, and you will find that in the active fleet of the United States Navy, there is an aircraft carrier named, yes, the John Stennis. Yes, there is an aircraft carrier currently on active duty where sailors and aviators, naval aviators from all racial backgrounds are serving, to include black sailors and aviators, named after a United States Senator who is a young prosecutor, prosecuted black men whose confessions to murder the U.S. Supreme Court ruled were coerced by the conduct that Judge Higginbotham wrote about. Folks, this is part of why we have the problem with policing of black and brown men. When the United States Navy can name an aircraft carrier after a racist prosecutor from Mississippi who became a United States Senator, it is clear that in the eyes of the United States military establishment, in the eyes of those people who are in charge of these things, racial injustice against people of color by the police and by prosecutors and by judges doesn't matter. John Stennis's career was not harmed at all by the fact that he was a racist prosecutor who enabled racist and abusive police conduct. He is remembered as an esteemed member of the Senate. And that's why I wrote that the hard truth is that for racial minorities in this country, The police have often been the foot soldiers in a long-standing effort to deny equal access to life, liberty, and property. That's why I wrote that we who are judges have to take account of these things. And that's why I wrote in my conclusion to Sean Johnson versus State that eventually people subjected to such police misconduct and the failure of judges to denounce it lose faith in the notion of equal treatment, and with it, lose faith in the notion of being part of the community. That alienation largely accounts for the difficulty police have in getting cooperation as they investigate reports of crime and locating witnesses. It contributes to why persons in poor and minority communities often are unwilling to respond when summoned for jury service. People victimized by a criminal justice system that purports to stand for equal justice under law while relegating them to second-class treatment by agents of government holding ultimate discretion in the use of force eventually become alienated from that system and the society that sponsors it. As their alienation increases, support for law enforcement will decrease. At worst, more people will become outlaws. As Professor David Cole has observed, he wrote, when significant sectors of a community view the system as unjust, law enforcement is compromised in at least two ways. First, people feel less willing to cooperate with the system, whether by offering leads to police officers, testifying as witnesses for the prosecution, or entering guilty verdicts as jurors. Second, and more importantly, people are more likely to commit crimes precisely because the laws forbidding such behavior have lost most of their moral force. When the law loses its moral force, the only deterrents that remain are the strong-arm methods of conviction and imprisonment. We should not be surprised, then, that the United States has the second highest then, he wrote that, it now has the highest, incarceration rate of all developed nations. And it should be no wonder that Black America, which has been most victimized by the inequalities built into the criminal justice system, is simultaneously most plagued by crime and most distrustful of criminal law enforcement. As I wrote in Sean Johnson versus State of Arkansas in conclusion, affirming the result of abusive, racist, and disparate police conduct sends the wrong message, that the courts will not protect the rights of poor, disfavored, and helpless people. No one should be surprised, then, when members of that group express outrage against police misconduct, even if one disagrees with the way that rage is vented. The greatest surprise and disappointment is that judges and other officials responsible for administering criminal justice refuse to acknowledge obvious inequities and do anything about them. We can't breathe. The judges don't care. We can't breathe. The prosecutors don't care. We can't breathe. The mayors don't care. We can't breathe. The bar associations don't care. We can't breathe. And now you know what that